Hello everyone, this is Jim giving you the Maryland Continuing Education YouTube video. Uh, for the Maryland agents, I just want to go over some recent updates that Maryland is involved with and to give you an idea of the requirements for some of the items that I found in the internet and going over some of the classes. There's an open house posted notice for Maryland open houses you need to use when an unrepresented person comes to visit your listing. You need to post it in a prominent place. The form is this. It's called Attention Prospective Purchasers Notice. You just post this form prominently in the house, and anyone that comes without an agent will be given notification that you are not representing them. They're represented by either themselves or by another agent. There's another form that I want to draw your attention to, when to use or not to use the tree conservation form. This form is found on what's called the Prince George's County Association Notice to Purchaser regarding tree conservation. The buyers may rescind the contract 5 days after receipt of the tree conservation plan disclosure. To obtain whether the property is in a conservation area, what you need to do is go to the PGAtlas.com website. There you would find an icon to the right that looks like a stack of papers. That's called the layers icon on the right side. Next, you'd use the development activities, and then underneath the same section, then the tree conservation areas. After you've clicked that icon, you just simply click on the map section and find the house location. If it's in one of those locations, if the home is in a conservation area, you can order a copy of the same thing on the website, but it takes about 20 days depending on their workload. So order on at the time of the listing. The same website, PGAtlas with S.com. The same website has also the Aviation Airport Environment Disclosure Notice, and you all probably are more aware of that than I am. This is the form here. Sorry, it's not very clear. This form, as you can see, you probably had some interaction regarding that. The same thing applies. You go to the similar to tree conservation area, you go to the PGAtlas with the S.com. You use the map layers icon again, then the zoning to the first entry aviation policy areas. As before, you click on the map and the section to find the house location. Those are disclosures that you would get from the seller regarding the tree conservation at times, but this is something the agents need to look up. Many times the owners don't know about them. Another area of understanding that will help you is the deferred water and sewer assessments. Disclosures is done using what's called the DNA form. This is the DNA form. You can see right there, DNA, dead on arrival, DOA, but DNA. This disclosure using DNA form for PG County. For MAR, there's a separate form called the Notice of Disclosure, which is the MAR form. So as you're aware, we have Maryland forms, PG forms, other jurisdictions. This is the Maryland version of this same form, and this says on it that this is incorporated in paragraph 17 of the MAR contract, and you still use this form to disclose. Disclose using the DNA form from the PG County. For MAR, there's a separate form. These forms were to provide disclosure to the buyer of possible fees due to the original developer of certain parcels for reimbursement to the developer for installing water and sewer infrastructure over a period of time. So the developers that develop some of the subdivisions, in order to get their money back for the output that they gave in the past, had up to 30 to 33 years for reimbursement to future owners. They would pay that, so that would be passed on to the new owner. It got changed to just 20 years as of October 2016. So to determine if there's such fees, the seller will give you their utility company information, where they pay their utility payments. You can call and find out with this information. Key is who they pay to. That's how you can tell. But the website, if you look up deferred water and sewer assessment, contact people are on that you can call if you have questions about it. But that deferred water and sewer assessment was a result of the developers getting reimbursed for their output of large sums of money to get the infrastructure in. I never knew about this, so I thought it would be interesting to share. If you have a home contractor, home improvement contractor, as of October 2016, agents previously needed to confirm license status of home improvement contractors for each job. Now it is the agent's requirement to know once a year if they're used by your client, what the status of the home improvement contractor's license is. So that's a requirement of the agent to know that for the sake of the seller or the seller who might be fixing their house. Not sure if you know about solar panels and leased items. Solar panels with FHA, if a house had solar panels that were leased, the value of the solar panels were not included in the appraisal. There's now a disclosure form, MAR's form. This is called the Disclosure of Leased Items Addendum to Residential Contract of Sale. That's given at the time of contract and signed by both buyer and seller. When the house is listed, there's an exclusion list for items that are leased. That could include propane tanks, that could include solar panels, fuel tanks, propane tanks. Also, this is not part of the sales contract, but it's a checklist for you as a listing agent to find out what items might or might not be leased. What takes place is that the buyer can, at contract, negotiate some of these items with the different vendors that have these leases. So lease panels, again, for the sake of appraisal, are not included in the appraisal. There's a separate form called Disclosure of Leased Items, and we just saw that for residential sales contracts. So just be aware of that. This also, the buyer form spells out what the buyer should be concerned with regarding leased items, regarding contract issues such as on-site sewage disposal systems, propane tanks. Last one is solar panels. If this form is not given to the buyer, they have a 5-day rescission period until they get that to cancel the contract. A few other items I thought were interesting. Disclosure of licensee status. If in Virginia you have a direct relative involved in a transaction, you need to disclose who that is as a licensee. The buyer is the cousin to the agent. The buyer is the sister-in-law. I did not know this in Virginia, but in Maryland, an employee of a real estate company, you have to disclose that they're an employee, or if they're part of an investment group and have an interest at all, you need to disclose that in a sales contract. So if you're buying as an LLC or some sort of corporation, any kind of property, or selling, the disclosure for anybody as a partner or a member of that group has to be disclosed as well. There's another interesting form in Prince George's County that you use this form as a receipt with the CMA you do. It discloses that the CMA is not an appraisal, and it just tells the seller the significance of a CMA. There must have been some issues with people relying on these as the gospel truth of the value instead of it being a opinion of value. So this form needs to be signed by the seller when you're giving them a CMA for a listing appointment. The notice to seller and buyer request for utility usage. This is a Prince George's County form, and this is called Form 1336. This is to ask the seller to fill out a disclosure form as to what the usage of utilities are, so the buyer has some idea what utilities cost. It also says in very prominent fashion that this is not guaranteed. Buyer further acknowledges that this in no way is intended to represent what its actual utility usage may be. if you purchase the property. But it's a disclosure of what they hopefully can expect the utility bills to be. Keep in mind, in Maryland, there's no dual agency. If you have a listing, someone wishes to buy it, we do what's called an inter-office assignment. Three other things. The condo disclosure law in Maryland, there's a 7-day rescission period and not a 3-day rescission period, to remind you of that. EMD, earnest money deposit, needs to be turned in within 7 days, business days. We ask that you get it in 3 days so that we can, if we have a weekend, make sure it gets in the bank. Again, if these earnest money deposit after ratification is not turned in, I'm obligated to contact the real estate board, and they'll investigate it if that's been late for any reason. Just my final thoughts: as buyers and sellers agents, never email acceptance of an offer or counter offer back to another agent by just an email statement. Only send fully completed contracts as evidence of acceptance. A written statement by email by you as the agent could obligate a client as binding without all terms signed and initialed. Only the principal can confirm acceptance in writing, never you as the agent. So to make that clear, you can't write back to someone saying we got a deal on behalf of a seller. You just send them a completed document or a non-completed. Real estate is done in writing. Do not make yourself liable for something that you have no ability to agree to. Only the buyer and seller in writing can agree to a ratified contract. Thank you for listening. Please write with any questions.